Chief Justice, and may it please the Court. This is the third time the government has come before this Court and asked to be relieved of the consequences of flouting the plain text of the INA. For a third time, the government says the notice it gave is good enough. Just as it did in Pereira and Campos-Chaves, this Court should reject the government's argument here. Indeed, the government's position in these cases is more extreme than its position in Campos-Chaves. In Campos-Chaves, the government said, as long as the non-citizen gets all of the information listed in paragraph 1, doesn't matter what format it comes in. In these cases, the government seems to be arguing that if you have a paragraph 2 notice, it does not matter if the non-citizen never gets any of the information in paragraph 1. And just to slightly amend the kind of nightmare hypothetical we're talking about, it's where the government sends the non-citizen a blank piece of paper, but nonetheless gives the immigration judge information about, for instance, the charges against the non-citizen. In that circumstance, the government can prove by clear and convincing evidence removability. The non-citizen has no clue what the charges against him are. And whereas in Campos-Chaves, the argument was that a deficient NTA was nonetheless sufficient to stop the clock for discretionary relief, here the government is arguing that same deficient NTA is somehow sufficient for the far more draconian sanction of removing a non-citizen without ever hearing their side of the story. Because the statute doesn't contemplate that result, because it requires a complete, valid paragraph 1 notice in every case and contemplates a paragraph 2 notice only as a supplement to that valid paragraph 1 notice, this Court should reject the government's arguments again. I welcome this Court's questions.
What's your best textual argument for your last point?
So, Your Honor, we think that there's two buckets of textual evidence. The first is about the sort of centrality of the NTA. So it's the fact that it shall be issued in every removal proceeding, the fact that it contains a bunch of information that's not in paragraph 2, and the fact that the statute says that a hearing can't be held less than 10 days from the NTA. So there's a presumption of the NTA. The second bucket is the language of 1229 paragraph 2, which says that a notice of change must be given only in the case of a change in the time and place of the proceeding. And we believe that the combination of those two, the centrality of the NTA, the change language that this Court has already interpreted in Pereira, adds up to our position.
I think it says any change, and that any change language seems to be broad enough for the change here.
So, Your Honor, again, that any change language is the same language that was interpreted in Pereira. And I don't think it's broad enough to encompass what happened here. If I could take the example from the government's reply brief of the voter registration form and the change of party affiliation form. If you mess up your voter registration form, if it's invalid, in the same way here the NTAs were invalid, it doesn't matter how many change of party affiliation forms you file until you fix that voter registration form. Filing a change form won't do any good. The same thing is true here. Because the NTA initially was invalid because it had the TBD language, it doesn't matter how many times you say I'm trying to change that. Until you've got the valid NTA, there's no change to be had.
Could I just ask